Nothing on the show is to be construed as legal advice. The contents of this show are for informational purposes only.
Hello, welcome to Know Your Rights, the Consumer Lawcast, with me, your host, Abbas Kazerounian. Thanks for tuning in again. Ladies and gentlemen, we have arrived yet again at a very, very sad time in our nation's history. On Friday, we had the highest number of COVID cases reported since the whole pandemic started, with 80,000 reported cases. And unfortunately, that's brought us to a place where consumers, people on Main Street are really suffering more than they've ever done before. And one of the biggest issues that we are getting calls about are tenants' rights, because obviously people are unsure about their rights. They don't know what's going on. They don't know what they can do, what they can't do. And I thought that I'd invite one of my good friends, Adam Rose, who is a consumer lawyer at the Frontier Law Center and the law offices of Robert Starr, to join us. Not only is he a friend of mine, I've worked with him on a bunch of cases, but he's a really, really great guy. And so with that, I want to welcome you, Adam, to the show. Thank you so much for being here.
Thank you.
So Adam does a lot of landlord-tenant work. And so he is here to kind of educate us and help us kind of understand where consumers stand as far as tenants' rights are concerned. But I think, Adam, like before we get to what the law became and the exemptions and the exceptions that were created during the COVID pandemic in the state of California by Governor Newsom, it's important for consumers just to generally know their rights as tenants. So like if we could go back to maybe 2019, when I believe the Tenant Protection Act of 2019 was introduced into law, you could give us some backdrop of, what procedures landlords would have to go through in order to evict a tenant, and just a very broad brush stroke, rudimentary understanding of what tenants need to know when they're in the eviction process.
Thank you. There were a few developments prior to the COVID protections that were instituted this year. And one of the main things which probably will affect the broadest swath of people is that rent increases in areas that are not rent control jurisdictions are capped at 5% per year. Normally, the landlord would have, if the building were not in a rent control jurisdiction, have pretty much unbridled reign to raise the rent as they saw fit. However, with the Tenant Protection Act of 2019, it's capped at 5% a year, plus cost of living or inflation. So that took effect of January of this year. The next important aspect of that act is generally when a landlord is potentially liable for what's called retaliatory eviction. There was not so much bite to that statute, but the revision to the statute allows for statutory attorney fees for the prevailing party. So if we could show that the landlord was using some sort of evil or bad intent in trying to get a tenant out of the building, retaliatory eviction has a stronger bite beginning of January of this year.
Got it. So let's go over those bullet points for the viewers and the listeners. So let's talk about rent control. I know that's a term that we read in newspapers, we see on the TV and the news, but so we can clarify it for our viewers, because remember, the lawyer, it's not lawyers that are watching this, it's the consumers. I think rent control was what you mean is when the landlord can only raise the price of rent by no more than 5% of what it was per year. Is that what you're talking about?
Yes, actually, some rent control jurisdictions it's even lower. That, for example, Los Angeles City, it can only be raised 3% a year. But for cities that don't have that kind of strong protection, now it's at 5% a year. So, of course, the lower percentage is the one that controls. But for cities, which are most cities in the state that don't have rent control, it's now capped at 5%.
And that's California-wide, right?
Yes.
So within the state of California, the maximum they can increase is 5%, but the local municipality has the authority to reduce that 5% to a lower number if they want to.
Right.
Got it. And then The other thing that you talked about was retaliation. So, like, when you say retaliation, does it have to be retaliation in the ordinary sense of the word, that they have to be retaliating to a certain conduct, or can they just have some nefarious kind of enterprise going on where they want to redevelop the building and they just want to throw people out, and that's also referred to as retaliatory, or like, can you help define that a little bit more?
It's more the first rather than the second. If the landlord is legitimately redeveloping his or her building for condos or family move-in, they can evict. But if the tenant has done something to try to assert their right, and a very recent example that has come up in one of my cases is we filed a case for our client for habitability violations, and the landlord then found some obscure part of the lease that they thought the tenant was violating. Whether or not she violated it, it's still the sequence of events shows that the landlord is trying to punish the tenant for exercising their right. So if the tenant, for example, makes a complaint about the condition of their unit, which is the most common thing, like it lacks heat or lacks water, and then the landlord does something to try to get the tenant out, that's retaliatory eviction.
Right, I understood. That's a really good example, actually. Thank you. And you said that the statute that was enacted in 2019 enhanced the rights of the consumer, so that if you have a righteous case, the prevailing party gets attorney's fees. Correct?
Yes.
So obviously, the upside to that is if you have a righteous case as a tenant, you're much more likely to be able to find an attorney like yourself that will take it maybe on a contingency rather than charging the tenant money.
Exactly.
I mean, that's an important note, because obviously tenants that are in like precarious positions with their landlords are not in a position to be able to afford attorneys, and that's something that always chills the effect of consumers and tenants specifically to be able to vindicate their rights, because they're always scared that they're going to be out of pocket to pay lots of attorney's fees. And one of the themes on this podcast is that, the things that we try and tell consumers is, most things that they're involved in, that they transact in, or they have rights under federal and state law. And if they know their rights and they're educated in their rights, more often than not, they'll be able to find scenarios like what you just described, where the consumer and in this case the tenants have the ability to get attorneys to vindicate rights for them, where they don't have to be out of pocket, which I think is a fabulous thing.
I totally agree. When I learned of that development, it led me to the exact same conclusion.
Yeah. I mean, that's great work that you're doing there. Thank you. So we had this development in, landlord tenant right, but like generally speaking, let's say that the tenant has fallen behind and the landlord has remedy at law to evict the tenant. All things being equal, in non-COVID times, like what are the procedures that the landlord still must go through in order to evict a tenant?
Prior to the developments that happened this year, the landlord would have to write a 3-day notice to pay rent or quit, explaining how much rent is owed, and then serve that notice on the tenant, telling them that they have 3 days to pay the rent and where to pay the rent. And if the tenant still did not pay the rent within that 3-day period, then the landlord could file a lawful what they call a lawful detainer, which is an eviction case.
Right, and that's done in a court of law. Right. Okay. And then, so what then happens is in kind of February, March of 2020, as we all know, the pandemic hit. And one of the first courses of action that Governor Newsom in the state of California took was bring in moratoriums and kind of create exemptions to protect tenants that have lost their jobs or been affected by the pandemic. Can you kind of like talk a little bit about that and the development of law in that regard since the pandemic started?
There has been a lot of activity since March on this issue, this general issue. The first was there was a statewide, there was a moratorium for eviction cases. They could not be filed until October of this year. So they can be filed now.
So they literally, like, there were no evictions from March or April to October.
For non-payment of rent.
Right. Wow. What else happened, if anything?
What else happened is there were two specified timeframes. The protected timeframe, which was from March to August, where if a tenant did not pay rent during that time period, they are pretty much absolutely protected from eviction as long as they filled out a financial hardship application, which is just a very easy one-page form explaining how their life or lives have been affected by COVID. That would protect them from an eviction case. It wouldn't protect them.
Is that something like I lost my job?
Right.
Or like, you know, I got ill myself, or my family member got ill and I had to look after them and things like that.
Or increased childcare expenses as well.
Oh, perfect. Okay, that's well thought out. And then, so what happened in August? Did that continue to October?
From August to the end of January 2021 is called the transition period. So the tenant, if the tenant does not pay rent during that time frame, they must, as long as they fill out the financial hardship application, they still have to pay 25% of their rent per month, up to 25%. And then when all is said and done, after January of next year, the tenants who are behind in rent have to start making up the lost payments. But there's still a protection for eviction, because as long as those hardship applications have been filled out, that's a defense to an eviction case.
Let me ask a question. So this application, is it like a government form you can get from somewhere, or is it a letter that you write that basically like adheres to those elements that you laid out?
The landlord has to provide it. And there isn't a standardized form, but the language that must be included is in the statute. So it's the landlord's obligation to make sure that when they provide notice to the tenant that they're behind on rent or they haven't paid it, that notice has to strictly comply with the requirement, or that's another defense to an eviction case if the landlord didn't provide the right type of notice.
Great. And then like, let me ask another question. I think that we've been getting a lot of questions on this as well, which is clearly, as you described, Governor Newsom in the state of California, and in other states too, there have been moratoriums. But let's be more specific about California, because I know that's where your knowledge is on, which is there's a misconception that consumers or tenants are forgiven the debt of the rent for the period that they didn't have to pay. But that's not quite accurate, is it?
That's not accurate, right?
So like they're expected to pay this after the pandemic is over, or like, can you talk us through that?
As long as a tenant has completed that financial hardship declaration / application, the tenant can make payment arrangements with the landlord.
Okay.
So it's not all at once.
Right. But so like the landlord can't come after like October and say, okay, you haven't paid rent for 5 months now. I want it all. You can't say I want it all at once.
Right.
And are there any parameters on what the arrangement can look like, that you pay like, you know, your rent plus a little bit, or like what that little bit looks like until you're caught up? Like, what does that look like? Or do we not know?
It's a little vague. It doesn't specify it from the statute, doesn't specify how the arrangement to repay the rent is supposed to be structured.
Interesting. So I think that leaves some flexibility for tenants. The way I look at that is like, you know, you could say, well, I can only afford to pay my normal rent plus 10% or something until I'm caught up. And I'm not sure. I'm not sure like what a landlord can do about that at that point. Like, it's like, well, I'm working with you. I'm going through the process that's laid out. And I think I've got a feeling just like on more like on bigger tenants, landlord tenant issues, like where the property is bigger and more expensive, that particular issue may get litigated, but that's to be
Probably.
that's to be seen, right?
I think you're absolutely right. I think that it will, because of the fact that the generally very active landlord caseload has now been paused. So there's going to be a big backlog of cases, which is why one of the parts of this new law from 2020 is that small claims courts also have jurisdiction over unpaid rent rather than just a unlawful detainer.
Right. Interesting. And then what I found interesting in some of the material that you actually provided to me before this podcast is the fact that the landlord's got some relief as well, because they don't necessarily have to go through the unlawful detainer process for unpaid rent anymore, right?
They can, yes, they can use small claims, which is, I don't know if it totally circumvents the typical way of going about an eviction case, but it is a supplement which hasn't happened before.
Well, I see that as a difference. I see that as being slightly different because when you go in for an unlawful detainer, from my limited experience of them, is that you evict the tenant and you get what's owed to you in monetary terms, right?
Right.
In the same judgment. But the way I read the Stabilization Act is that the landlord can go to small claims to get unpaid rent, but I don't think can use the small claims forum for eviction purposes.
True. You're right. The small claims court cannot give a judgment of possession.
Right. And so I think like there is a distinction with a difference, which is like you can do both in unlawful detainer, but you can only ask for the money owed in small claims.
Right.
Do you see what I'm saying?
Yeah, I do.
So, and then like, are there freezes on rent control and things like that in LA that you've seen at all?
Los Angeles has a complete freeze on any rent increases at all until the mayor makes a supplemental order that the emergency has ended. So right now there's no rent increases, period. And I have a feeling that other big cities probably have a similar type of moratorium, but I haven't looked into it because
Right.
I figured the Los Angeles one is so broad and that's going to affect the most amount of people.
Yeah. I mean, I feel like this is an area that consumers and tenants have to literally be like watching on a daily basis because the directives coming from the governor's office, from the different mayors, from the different cities are continually changing because they're reacting to the status of the pandemic and how the populace is reacting to the pandemic. And I feel like we're going into the biggest surge that we have seen since the beginning of the pandemic began in February, March. Right now, we're right in the middle of it as we speak, because of the numbers I just gave you on Friday that were coming from a nationwide stats. And I feel like there's going to be more changes coming. I don't know that, but what is your feeling about that? I mean, I know this is not fact. This is just your opinion, but like, I feel like there's been so many different changes and directives that it wouldn't be a shock that if we get a new one in the near future.
I totally agree. I think that the level of the comprehensive statutes that were enacted this year show a great deal of forethought, but more forethought will be used in the coming months. So yes, there's possible that we'll see even more additions to this.
Sure. Now, like, I think, you've done a really great job for our viewers and listeners in kind of giving them the basics of what's going on. Now, if I'm a tenant and I've been making do thus far, but I'm anticipating that if this pandemic continues, I'm going to be in a bad position. Are there any things that I can do to prepare for such a scenario, or like get my family ready so that I can be in the best position possible to deal with the worst case scenario for me, which is I lose my job and I can't pay rent?
I think that the way that the new statutes are worded, people are going to be protected for quite some time. As long as that financial hardship application is completed, then the tenant, whoever is suffering a hardship, should feel some security in the fact, as long as they've complied with the prerequisite.
Absolutely. And if I may have my own, I know you're the subject matter expert here, but if I may add my own suggestion, is one of the fundamental takeaways from this podcast, ladies and gents, is the fact that you have rights, number one. Number two, a lot of the area of landlord-tenant is covered by statutory given attorney's fees, which means that you don't necessarily have to pay attorney's fees in a lot of those scenarios if you have a case, which means that a lot of attorneys give free consultations, okay? And I'm not sure if your firm does or not, Adam, but what I am going to tell our viewers is, if I could give you a tip, as from what I've heard from Adam today, and my general knowledge of law and my practice in the years in the area of consumer law, is the number one tip I can give you is don't just assume anything that you have no rights or no options. Call someone like Adam, and a lot of these lawyers will give you a free consultation and they will tell you your rights. And in a lot of scenarios, you will be surprised to know you do have rights, and maybe they can be vindicated without you actually having to be out of pocket. That's fair?
Absolutely. Absolutely. I totally agree.
And,
There's a lot of iterations of things that can happen in a landlord-tenant relationship, and you're absolutely right. Discussing them with someone could lead to other things.
Right. And so, like, if one of our viewers wants to get in touch with you, Adam, is there an email address or a telephone number they can call? And if you could say it a few times, and then Zach, our producer, is going to make sure that it's on the bottom of the podcast when you actually say it, so that they can the consumers can see that.
Absolutely. It's 818-225-9040, and I'll repeat it, 818-225-9040.
Awesome. So, listen, Adam, it's been an absolute pleasure having you on our show. I've always enjoyed chatting with you. I've always enjoyed co-counseling cases with you. You've been such a great advocate for consumers, and a zealous advocate for that too. Once again, I just want to stress that Robert's firm doesn't just do landlord-tenant. At Frontier Law Center, all the law offices of Robert Starr, they are an all-encompass, all-inclusive kind of law firm that protects the rights of consumers. And great friend of the show, great friend of my law firm. And I really am thankful for you coming at short notice to assist our viewers with all the good knowledge that you've put out there. So thank you.
Thank you so much.
Of course. And ladies and gentlemen, thank you always for tuning in and listening to what we have to say. If you have anything, you know where to get hold of me. You have my information. You have Adam's information. And until next time, keep it legal.